Hey there, GoPo kids. It's Mr. Chef here, starting the lecture on the judicial branch. So we've finished off bureaucracy. Hopefully you've watched both of those already. From looking at the Google Analytics, I would say you haven't. But you're going to need that for the AP test, ladies and gentlemen. It is material that you need. So today I'm going to start off with the judicial branch, which is a little more extensive than the bureaucracy. So I'll probably end up having more like 3 videos on this that are about 35 to 40 minutes each, because I just can't talk much longer than that without my voice going out. So, all right, here we go. So I'm gonna start sharing my screen here and we'll see how it goes. All right, so I'm going to make that smaller because I don't want that to be the big deal there. And I'm gonna make that a little bit bigger. Okay, so here we have our current Supreme Court. We right now have a relatively conservative tilt on the Supreme Court. I'm going to get more into the Supreme Court on a lecture by itself. But we have our current makeup of 5 relatively conservative justices. The 2 new ones here are Brett Kavanaugh and Neil Gorsuch, appointed by President Trump. We have Justice Alito and Justice Thomas, are both conservative justices. Justice Roberts here is a relatively conservative justice, sometimes can be the swing vote. Liberal justices, we have Justice Ginsburg here, Justice Kagan, Justice Sotomayor, and Justice Breyer are liberal justices. That doesn't mean they always vote the same way. There's been many times where members of the Supreme Court will flip-flop and go to the other side. In fact, about 1/3 of all Supreme Court decisions are unanimous and they vote together. So, but we always have an odd number of Supreme Court justices, but I'll get more to the Supreme Court specifically later on in a different lecture. So let's just start off with federal courts here. So I always start off with this question saying, do justices interpret the law or do justices actually make the law? That is, are justices just interpreting what the Constitution says, or do justices actually make law through their interpretation? For example, the 4th Amendment says there should be no unreasonable searches and seizures. Well, the Supreme Court gets to decide what unreasonable means. The 8th Amendment says you shouldn't have any cruel, unusual punishment. Well, what is cruel and unusual? So the Supreme Court gets to decide what that means. And so it's been said that the Supreme Court is just a constitutional convention always going on, because we are literally saying that judges, through their interpretation of the law, are literally making law because they're filling in the gray area that goes on. If this sounds familiar to you, this is all the way back from October, when we talked about an evolutionist approach versus a originalist approach, or a strict constructionist approach to a loose constructionist approach, right? And so we're going to get more into that when we talk about judicial activism and restraint. All right, so let's move on here. Okay, so introduction into federal courts, okay? There's really 2 types of laws that are courts here: criminal law and civil law. Criminal law means you broke a law, like I stole something from you, so that's part of a criminal law. And then there's civil law, which is where 2 or more people are suing each other, like you broke a contract with me, so I didn't commit a crime against you, but I am suing you because I think you owe me money. And so those are the 2 major types of law that we have here. The big thing we need to know about federal courts is that when they make a decision, specifically the federal appellate courts or the Supreme Court, they set a precedent for the future, meaning that from here on out, every legal decision is going to be based off what they decided in their case. And that's why the federal courts are such an important part of our government, because when they decide a case, or when they issue what's called a judicial opinion in the case, they are literally writing a law, and those laws carry legal precedent. So from here on out, everybody has to follow what the Supreme Court says. For example, if you remember from civil liberties and civil rights, Gideon versus Wainwright, which is the 6th Amendment's right to an attorney, was incorporated through the 14th Amendment's due process clause. Well, that established the precedent, the Supreme Court, with their issue of Gideon v. Wainwright, that every single person at the state and federal level had to be issued an attorney if they were going to be put on trial for a crime. That precedent was established from here on out. So that's one of the key things we're looking at with federal courts, specifically the appellate courts and the Supreme Court, is that when they make a decision, it establishes a precedent. Okay, so now, arguing that judges do make law or arguing that judges don't make law, this would be an argument against that judges make law, because we say judicial power is passive, okay? Meaning that judges at the federal level can't just make up a case and then make a decision on the case to change the law. Judges have to wait for a case to come to them to make a decision on it, okay? For example, Roe v. Wade dealing with abortion. There might have been many justices on the Supreme Court that thought that a woman's right to an abortion was protected by, which amendment, ladies and gentlemen? Which amendment? Which amendment? Which amendment? I'm trying to be entertaining here because I still don't like this format. The Ninth Amendment right to privacy. And so there could have been judges that were on the Supreme Court that thought a woman did have the right to an abortion through the Ninth Amendment's right to privacy. But those judges couldn't just create a case and then make a decision which made abortion legal. Their power is passive. They had to wait for a case to come to that was appealed to them by a lower court. And so we'll get to that later, okay? Also, many cases get thrown out because somebody has to have standing to actually challenge a government law. Standing means you have to prove that you have somehow been damaged by a previous court case or by a law that was passed. So let me come back to the Roe v. Wade example. You couldn't just get a woman who thought she had a right to an abortion and then say, I want to change the law. There had to be standing that a woman showed that she was damaged by not having the right to an abortion in the case. So what did that mean? It means it took a woman that was pregnant and then could not actually get an abortion. She then said, I had standing because I was damaged by these laws at the state level that didn't allow me to have abortion, and therefore she could prove she was damaged by a law. Okay, so even if people don't like the fact that a law is in place, there has to be standing for them to actually take the court to the state level, appellate court level, or the Supreme Court level, okay? I'm gonna try and stop this screen share here, and I wanna try to do something else. We'll see if I can go whiteboard. Yes, there we go. And let's see if I can draw. Okay, so federal courts. Federal courts, there are literally 3 levels of federal courts. Oops, okay, good, that's done. Let me draw another one. And I think I've done this before, but I'm gonna do it again. Yes, that's a triangle, whatever, it's not exactly perfect, but whatever, okay. First time I've done this, and I didn't even practice this. This is actually pretty good skills for never doing it before, and I'm just figuring out as I go. There we go. All right, so there's many different federal courts. There's military courts. We're going to be concerned with 3 layers of federal courts. Okay, the bottom level here, and you can write this in when you're watching it, these are called district courts. District courts are the trial courts of the federal government. District courts are where if you commit a federal crime, you'll be tried. That's where you have a judge, you have a jury, you have a prosecuting attorney, a defending attorney, maybe a plaintiff, maybe a defendant, right? All those type of things. So district courts are your typical courts you see on TV where somebody's found guilty or innocent of a crime, a federal crime only, and they only have jurisdiction to put people on trial for committing federal crimes. Like, for example, counterfeiting money is a federal crime. You could be put on trial at a district court. I believe there are 94 district courts, and every single district court judge is appointed by the president and confirmed by the Senate like every other judge, okay? The next level up are appellate courts. Appellate courts are cases that they only hear cases on appeal. That is, a court has been tried at the lower district level, and then the person who lost the case doesn't think the right decision was made, so they can appeal to the appellate court. I believe we have 12 different district courts of appeals, and I think there's about 180 judges that sit on those benches at the federal level between those 12 district courts. State courts can also have cases appealed from them. So if, let's say, at the California Supreme Court issues in a decision and somebody doesn't think the decision was correct with the Constitution, they can appeal to this level right here. These are the appellate courts. So let me see if I can just draw some text in here. These are district right here. I'm just figuring this out as I go, ladies and gentlemen. So there we go. All right, district, that works. Cool. Let's do another one here. Appellate, nice. Yep, that's gonna work. Cool. And then at the very top level right here, ladies and gentlemen, this top level is the Supreme Court, okay, or SCOTUS, the Supreme Court of the United States. Let me see if I can move this around here. Okay, so there we go. Nope, that's not going to work. All right. The Supreme Court, though, has the ability to both try a case for the first time and to hear a case on appeal. And I'm going to get to this later, I think, when I talk about jurisdiction. Jurisdiction means who has the right to hear a case first. Okay, so so there we go. All right, so I'll get back to this more later on, but these are the three levels we're going to talk about: district courts, trial courts in the United States; appellate courts, they hear a case after it's already been tried and they're trying to make sure that the Constitution was followed. They have what's called appellate jurisdiction. And then Supreme Court can hear a case for the first time, but rarely does. They mostly can hear a case on appeal. They can hear a case on appeal from a district court, from an appellate court, or from a state level as well. Okay. All right. So let's stop that share. Very good. And let me come back to this one here. Okay, so I was just telling you about jurisdiction, ladies and gentlemen. Okay, jurisdiction. I'm going to come back to this. So do judges actually make laws, or do judges just interpret the law? Okay, well, let me give you some stats here. Let me see here. Woodrow Wilson, by the way, was the quote that said, "The Supreme Court is a constitutional convention in continuous session." So judges do interpret the law, but they do in fact make law when they interpret the law. Okay, so let me give you an example. Okay, a state writes a broadly worded law, and then the Supreme Court actually would get to fill in what that state law would mean. Or a federal law is written, it's broadly worded, and the federal court would actually get to fill in what the law really means. Those are called opinions. But so some stats on this. Federal courts have ruled that 1,000 state laws have been unconstitutional. The Supreme Court has ruled over 130 times. It's more than that now. I need to update these, that federal laws are unconstitutional. Over 200 times, the Supreme Court has reversed itself and said that its own ruling about the Constitution was wrong, and they switched it to unconstitutional. Okay. I'll give you an example of the Gideon versus Wainwright. In Gideon versus Wainwright, there was a case 20 years earlier, I believe it was Batts versus Brady, that said, no, the states don't have to provide you the right to an attorney. And so the Supreme Court had ruled, I believe in 1943, that in Batts versus Brady, states didn't have to provide you an attorney unless there was some special circumstance. And then 20 years later, in Gideon versus Wainwright, which I believe was 1963 or 68, I can't remember, they ruled that no, the states do have to provide you the right to an attorney. So over 200 times, the Supreme Court has reversed its own decision. Another one from history that you might remember, Plessy versus Ferguson and Brown versus Board of Education. Remember, Plessy versus Ferguson was the separate but equal law, where the Supreme Court ruled that you could have segregated schools as long as they were equal. And then 60 years later, approximately in 1954, the Supreme Court in Brown versus Board of Education reversed its own decision and said, nope, separate but equal is unconstitutional because we're denying students equal protection under the law from what amendment? What amendment? That's right, the 14th Amendment, equal protection under the law. So there we go, okay? All right, so now let's talk about jurisdiction. Exclusive jurisdiction means that somebody has the sole authority to hear the case for the first time. So for example, if there's a case involving treason, federal courts have exclusive jurisdiction about that. That would not be a state level court. Only the federal government would have the exclusive jurisdiction. Jurisdiction means who gets to hear a case first, okay? Would it be a local court? Would it be a state court? Would it be a federal court? Who has jurisdiction? Original jurisdiction just means who gets to hear the case first. So you can have a case that say originates at the federal level, like let's say a counterfeiting case, and that case would have original jurisdiction to say the district court level. Remember that triangle that I just showed you. But then it could be appealed to the Supreme Court if, let's say, the defendant or the plaintiff didn't think that, or if the defendant didn't think the case was ruled correctly in accordance with the Constitution. So appellate jurisdiction is being able to hear a case after it's already been heard at a lower level, okay? So appellate courts, that's all they do. they hear a case after it's already been tried at either a lower state level court or at the district court level. And they are going to review the court's decision or opinion or decision and decide, was the Constitution followed? Okay. And then a concurrent jurisdiction is where both maybe a state and federal court would have the right to hear a case. Okay. So for example, let's say somebody committed a crime and they committed a crime which crossed several state lines, and they committed state crimes and federal crimes. They would maybe both have jurisdiction on that. Okay. But what are some cases that involve jurisdiction of the federal courts? Any case involving the Constitution where a law might be misinterpreted from one state to the next, that's going to go to the federal courts, because we don't want to have the Constitution being interpreted 50 different ways. So the federal court, specifically the Supreme Court, would have jurisdiction to hear that case. Okay. Any case involving maritime law, that is law on the seas, that's federal jurisdiction. They would have original jurisdiction. If there's ever a dispute between two or more states, the federal government would have original jurisdiction over that. Okay. Any case involving ambassadors from another country, the federal government would have jurisdiction on that. Okay. All right. So there we go. Okay. I've already given some examples of cases they've heard right there. All right. So let's move on to this. There's a lot more information I would normally give you if there was multiple choice going on, but there's not multiple choice going on today. So in this year's AP test, so we're going to change that a little bit. Okay. So there's some stuff that I have on here that I know I'm just going to skip because I know it's not going to be on the AP test this year. All right. Federalist paper number 78. Hopefully you have already watched the 10-minute video I put on Federalist paper number 78, but just to review to your head, what was Hamilton trying to argue about Federalist paper number 78 and the judicial branch? In your head, review it. Dun, 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 dun. Okay. He was arguing for lifetime appointments for judges, for federal judges, and no elections for federal judges. So judges should be appointed and approved, appointed by the president and approved by the Senate, not by Congress. And once there, they should serve lifetime. Why? Because it frees them up from political pressure. It allows them to have independence and be the protector of minority rights from tyranny of the majority, right? So if you haven't watched that already, ladies and gentlemen, very, very important that you go back and watch my 10-minute video that I did on Federalist paper number 78, okay? And I will post, I still haven't done that yet, but I will post Federalist paper number 78 and the worksheet that goes along with that to Google Classroom, okay? All right. Gosh, I've already talked about district courts. I've already talked about appellate courts. I'm kind of just giving you the basis of what they do here. Yeah, okay, so this is showing you our district courts of the United States, ladies and gentlemen. Okay, so these are showing, sorry, our appellate courts of the United States. Okay, so if there's a case which happens in California and it gets tried at the state level, and then you are not happy with the decision of that, you can appeal from the state Supreme Court of California to District Number 9 Federal Court. And then if you don't like the decision that was made at District Number 9 Federal Court, you also have the ability to then appeal to the Supreme Court as well. Okay. Gosh, I'm trying to think what else. Oh, something else I want to mention that I forgot to mention on the Federalist number 78 is that Hamilton also argued in Federal 78 that one of the reasons we want judges to serve lifetimes is we don't want incompetent judges. Judges that are appointed and then approved by the Senate and then serve for life know the law. And we don't want to have judges cycling through which are incompetent and are not qualified and don't know the full ins and outs of the Constitution. Okay. Okay, let's keep going here. Yeah, normally I would cover this stuff. I would cover Solicitor General, but I'm going to guarantee you this is not going to be on the test. I do want to say that the vast majority of cases that reach criminal courts never see the inside of a courtroom. So those Solicitor Generals who represents the United States whenever the United States gets sued. And so the Solicitor General is sometimes referred to as the 10th Justice of the United States because they're or the Solicitor General's office, they are representing the United States in front of the Supreme Court so much, they're sometimes referred to as the 10th Justice of the United States. The Attorney General is the chief law official in the United States. So the Attorney General is appointed by the President, confirmed by the Senate, and they're the ones for administering federal law. But most cases that reach the United States at the district court level never see the inside of a courtroom. They get what's called plea bargained out. That is, if somebody commits a federal crime, the U.S. attorneys will offer them leniency in their sentencing if they agree to plead guilty for the crime. And that way they don't have to tie up the court systems. We don't have enough courts in the United States to prosecute every single crime that gets committed. The vast majority of cases that ever reach either federal or state courts get plea bargained out. They never, or even county courts for that as well too. Almost all criminal cases get plea bargained out. Very few ever see the inside of a courtroom. Coming back to the bureaucracy, these U.S. attorneys, they only serve 4-year terms, and they are appointed by the president as well. These are kind of key patronage positions as well right here, okay? All right, so all federal judges. So this is trying to show how partisan it is when judges get appointed, because my next I'm trying to, how do judges get to be judges? This is showing you how partisan in nature judges getting appointed are. And so the cartoon is showing you the perfect Republicans of the Supreme Court, meaning that who is a Republican president going to appoint to the Supreme Court? Just like, and who would a Democratic president appoint to the Supreme Court? Well, let's come back up here to this picture right here. Neil Gorsuch and Brett Kavanaugh are both considered conservative justices, and they were appointed by President Trump, a conservative president, somewhat conservative, right? Both Elena Kagan and Justice Sotomayor were appointed by President Obama, both liberal justices, okay? So typically you're gonna get a president that's gonna appoint judges that have a similar political ideology of them. Now, what's to prevent the president from just appointing extreme conservative justices? Well, the makeup of the Senate. If the president has a Democratic controlled Senate and the president's a Republican, the president can't appoint extreme conservative judges because they wouldn't be confirmed by the Senate. So if you have a divided government where the Senate's one party and the president's another, you're going to get a more moderate justice, which is going to be appointed by the president. In this case of President Trump, we have a Republican controlled Senate with a Republican president. And so we got 2 relatively conservative justices. If the Senate had been controlled by the Democrats, Justice Kavanaugh and Justice Gorsuch would have never been confirmed by the Senate. They wouldn't have done it. They would have made President Trump pick a more moderate justice. Same thing like President Obama got to appoint Justice Kagan and Justice Sotomayor because the Democrats controlled the Senate when they were there. One thing that has changed, and I think I mentioned this before, there is no more filibustering of judicial nominees. So it used to take 60 votes to confirm a member, especially to the Supreme Court, but that can't happen anymore. So because the filibuster's gone. So they just need a simple majority now to confirm. I'll say this, if the filibuster was still in place, I don't think Neil Gorsuch or Brett Kavanaugh would have been confirmed because the Republicans wouldn't have had anywhere near the 60 votes needed to do that. So President Trump would have been forced to nominate a more moderate justice, okay? All right. So all federal judges are appointed by the president and confirmed by the Senate, and they get to serve life terms, but Article 3 says as long as they're on good behavior, okay? So factors affecting the selection of that, I just went over that. Senatorial courtesy is where that's not going to be on the test. It could have been a multiple choice question, but this isn't going to be on this year's test. Again, the Senate Judiciary Committee, which political party controls that is a big deal on who gets selected to be a judge, especially at the Supreme Court level, If there is an FRQ talking about how to check the Supreme Court, right? How to check the Supreme Court is by the president getting to appoint justices and the Senate getting to confirm those justices. So I could see that being a way that be a possible FRQ is, say we have a concept application and they give you a quote by an opinion that was issued by a Supreme Court, what is one way that that Supreme Court could be checked? And you could say that the nomination of future judges by the president and the confirmation of those judges by the Senate could alter the makeup of that court in the future. Okay, so take a look at this. This is showing you judicial nominees by race, ladies and gentlemen. All right, and even with our most liberal president we've had in years, Barack Obama, you could still see that the vast majority of justices that got elected were white. Okay, all right. President Reagan was actually the first president to put a woman on the Supreme Court. Justice O'Connor was actually nominated. Reagan was a conservative. So Reagan actually was the first one to put a woman on the court. Now, she was a conservative, but she was the first woman. Herbert Walker Bush nominated a black man. I'll show him right here, Justice Clarence Thomas. But when President Bush nominated Clarence Thomas, he's a conservative, and he's probably considered to be, if not the most conservative justice on the Supreme Court today. I think Justice Alito might give him a run for his money. But still, Bush, a Republican, did nominate a black person to the Supreme Court. So it doesn't necessarily always have to be white men that get appointed, but it does. All right. This is actually taken from an old FRQ. And we have the Supreme Court, and they're chanting 40 more years, 40 more years. And this is showing you how important it is for a president to get nominees on the Supreme Court, because presidents getting nominees on the Supreme Court justices nominated and confirmed, it's like they're extending the presidency. So President Trump that nominated Kavanaugh and Justice Gorsuch, Kavanaugh and Gorsuch are going to be on the Supreme Court long after the president is gone. And so the president getting nominees on the Supreme Court, it's like extending their presidency. So coming back to this is, who is the president going to choose? One of the things that presidents are going to choose affecting this, yes, their political party, yes, the makeup of the Senate, yes, their race and their sex and their gender, but also their age. The president would like to appoint relatively young justices. And when I say relatively young, I mean in their 50s, because it's not uncommon for justices to serve well into their 80s. And so if a president can get a young president, a young judge on the Supreme Court, it's like they could possibly be extending their presidency for 30 years. Okay. Now, how do we know what the ideology of a judge is before the president nominates them? Well, judges are required to write judicial opinions. When judges hand down decisions, they are required to write opinions on why they ruled the way they did. And also they sometimes write and publish things. And so based off those, we can get a pretty good idea of what a judge's ideology is based off how they've ruled in previous cases and based off judicial opinions, which I'm going to get to later on, of which way they're going to go. But not always, because I think I talked about this in Federalist Paper number 78. Judges can stray. Just because a judge is a conservative judge or a liberal judge doesn't mean they're going to stay that way. And the example I think I gave you in Federal 78 was David Souter. David Souter was nominated by President H.W. Bush, and the president that served in the late 80s, early 90s. And he was a relatively moderate conservative justice, is what President Bush thought. Because the Democrats controlled the Senate, President Bush had to nominate a relatively moderate conservative judge, David Souter, because otherwise they wouldn't have been approved by the Senate. Well, David Souter, once he was nominated and once he was approved by the Senate, turned out to be a relatively liberal person and sided with the liberal majority, or the liberal part of the Supreme Court, way more than conservative. But there was nothing that President Bush could do about that because they serve for life. So sometimes they stray. Justice Gorsuch and Justice Kavanaugh have had many cases where they've sided with the liberal judges in the Supreme Court. And so just because a judge gets appointed with a set ideology they think they have, they're not bound to do that. They can stray from that, and it's not uncommon for that to happen. Okay. What else? Okay, as far as like FRQ on this part, I could possibly see an FRQ coming out talking about should judges have lifetime appointments. You know, should, and you would then, of course, like an argumentative essay, maybe should they would give you a quote about this, and they would maybe give you primary documents of using the Constitution, Article 3, Federalist Paper number 78, or a non-primary document, either arguing in favor or against lifetime appointments based off that. And so I could see an argumentative essay being put out there about should judges have lifetime appointments? Should judges have to be reappointed every once in a, every so often, say every 10 years, 15 years, or should judges have to be elected by the people? And so I could see an argumentative essay going that way. And if I were you, I'd maybe think about how would you argue in favor or against lifetime appointments using Article 3 of the Constitution and what they've laid out for the judicial branch, and using Federalist Paper number 78. Okay. All right, so I'm going to go past this. Another check that we could say is how could we control an out of control judicial branch is that Congress can actually increase or decrease the number of justices on the Supreme Court. Okay. Congress can actually increase the number of federal justices. They can increase the number of Supreme Court justices, and they can also decrease them as well. And so if we thought that the judicial branch was not behaving appropriately, Congress could actually increase the number of justices, allowing the president to appoint more justices to the Supreme Court being confirmed by the Senate, and those newly appointed justices would outnumber the existing justices either on the Supreme Court, appellate courts, or at the district court level, right? Congress can also reduce the number of justices on the Supreme Court as well. They can't kick a judge out, though, because they serve for life, just meaning that as that justice retired, they wouldn't be replaced. FDR attempted to do this, if anybody remembers from U.S. history. That was called court packing, where FDR attempted to get Congress to increase the number of federal justices so he would get to appoint those new Supreme Court justices, because the Supreme Court kept declaring a lot of FDR's programs unconstitutional. Okay. All right. I think that is a good stopping point for this right here, because my next part is judicial activism and judicial restraint, and I want to spend quite a lot of time looking at that. I think what's important about what we just talked about here is knowing how judges get appointed, knowing what factors are going to impact those judges that the president takes into consideration, and knowing that judges, do they write law? Are judges interpreting law, or are they making law? And remembering Federalist Paper number 78 and why they have lifetime appointments, and understanding what jurisdiction is and how that actually impacts judges' power. Okay. Again, email me if you have any questions, ladies and gentlemen. I have office hours on Thursday from 9 to 11 of where I know I'm supposed to respond to emails, but I'll respond to an email anytime you give them. I'm already responding to several students. Okay. So, practice FRQs, ladies and gentlemen. Practice your argumentative essay FRQs and practice your concept application FRQs. I have tons of examples that I've already put on Google Classroom for all the units that are on there. Okay, everybody, I'll talk to you later. And let me stop the screen share here and stop recording.